Hello, everyone. Thank you for coming to our Amending Your Declaration 101 webinar. My name is Cliff Davis. I'm a shareholder here with Roberts, Markel, Weinberg, Butler, Haley. Today, we're going to touch on a few things. Amending your declaration will be one, but we're going to also talk about a few other things, governing documents, and kind of a brief overview of collections and deed restrictions. We'll get started with a little overview of what we are going to touch on. The first is the hierarchy of governing documents, the amendment of documents, including deed restrictions and all the policies and rules that an association may have, a little bit about deed restriction enforcement and collections foreclosure. So let's start with dedicatory instruments. So dedicatory instruments is kind of an umbrella term for all of the governing documents of the associations. It can be the plat, the declaration, any policies or rules you have. It's a broad term that includes all of those. Typically, the first dedicatory instrument that's filed is maybe a plat, and what the plat is a map of the subdivision. If you've ever looked at a deed to your property, you'll see that it'll say something like Lot 1, Block 5, and the name of your subdivision. And that is called the legal description, and that is a reference to the plat. So if you find your plat map, you'll see that it's partitioned out into blocks and lots. And if you find your lot and block number, that's where your property is located. Plats generally don't have many restrictions on it. They probably have a residential use only restriction on it. They may have some setback lines on them and building lines, and they'll mark off easements. And so that's one thing that is part of your governing documents that may contain some restrictions on where you can locate buildings and residences on the property. So typically the plat and the declaration are kind of the first two governing documents. And the declaration is the rules of what you can and can't do with your property. So a lot of times we hear people talking about the bylaws and the declaration, and they kind of get the terms, use them as they're the same document. They're not. The declaration is the actual rules of what you can do with your property. It sets the assessment rate, and that you have to pay, you're obligated to pay the assessment to the association. And then kind of the third of the first three important dedicatory instruments is the certificate of formation, which used to be called the Articles of Incorporation. And what that document does is that creates the association, typically created as a nonprofit corporation in the state of Texas. And it may also have some restrictions, and not really restrictions of what you can do with the property, but some guidelines on how the association will operate. And if sometimes those may be in conflict with the declaration. If they are, you need to look to your declaration to see if it addresses, if there's a conflict between the two documents, which document will control. But that's somewhat rare that there's a conflict between the declaration and the Articles of Incorporation, now known as the Certificate of Formation. So really, those are kind of the big three. Your developer forms a nonprofit corporation through the Certificate of Formation. They get a set of deed restrictions, also called the declaration, the rules of what you can and can't do with your property. They file that with the county. And then they have a plat map that's also filed with the county that outlines your subdivision. And it may be that your subdivision, that your association is made up of several different subdivisions or sections. And there's a plat map for each one. So we have some associations where there's one plat map. And then we have some associations where there can be, anywhere from 5 to 30 plat maps of different sections that are under the jurisdiction of the association. And then we get to your other types of dedicatory instruments. And probably the most important of those are the fourth document that a developer puts in place are your bylaws. And the bylaws are the administrative rules under which the corporation functions or operates. It's not the rules of what you can do with your property. That's the declaration. There may be some rules in bylaws, but typically you don't find rules there. What you find there is information about annual meetings, board meetings, quorum, notice of meetings, the election of directors, how that's going to happen, the powers, duties, authority of the board, and the officers in the association. So these are all in the bylaws. Your bylaws should also be filed with the county in order to be effective, and we'll talk about that a little bit. Nowadays, most aspects of how the association operates are controlled by the property code. So a lot of bylaws kind of are a recitation of what is in the property code. And whether it's not in your bylaws, the property code will control over certain aspects of the operation of the association. If you have bylaws that haven't been amended, let's say in the last 5 years or more, you probably need to amend your bylaws. My guess is there's some provisions in there that might conflict with the law. And even though the law controls in those instances, it won't be rare for an owner to be reading the bylaws and say, hey, you're doing this wrong. The bylaws say one thing, and then you're put in the position of having to explain, well, we understand the bylaws say that, but the law says this now, and the law supersedes these bylaws. So it's a good idea, if you can, to amend your bylaws. We're going to talk a little bit about how you might be able to do that without a vote of the owners, just the board amending. We'll talk about that a little bit later on here. Another type of dedicatory instrument are architectural or builder guidelines. These are usually guidelines or rules that affect what can be built on the property that are not included in the declaration. They're typically adopted by the board or perhaps by the Architectural Control Committee, and they can be amended by the board or the Architectural Control Committee. A lot of declarations, a lot of deed restrictions reference the ability of the association or the authority of the association to adopt guidelines. And so you need to really look at your declaration and see if there's that authority is there. And if it is, who has that authority? Is it the board that has the authority, or is it the Architectural Control Committee that has that authority? And then there's rules, regulations, and policies. A lot of times a law will pass and the law will kind of dictate that a policy must be filed in accordance with the law. And again, these are things that the board will adopt and amend when necessary. The board may adopt a policy for rules on common areas for your swimming pool, or for the use of parking lots that the association owns that are next to your facilities. If they don't want overnight parking, the board can adopt rules that govern those pieces of property that are owned by the association. And then there's always statutory law, federal, state, and local. Typically, it is going to, if a deed restriction or a rule conflicts with state law, the state law is going to control. So you always have to be aware of what the laws are. And your boards are going to rely on the management company. And if you're a homeowner out there or a board member watching, these are things that your management company should keep you apprised of, and your attorney. We typically, when the law changes, kind of send out a mass email or newsletter or something trying to let everyone know that, hey, the law's changed, and we need to make sure that the boards out there of the associations are aware of these law changes. We'll talk a little bit about amending the document. So there's different standards for amending the different dedicatory instruments. For the Articles of Incorporation, also known as a certificate of formation, it's typically 2/3 of all members, and that's statutory to amend those documents. And you might say, why do you want to ever amend those documents? Well, it may be that your Articles of Incorporation say that non-members, meaning non-property owners, can serve on your board. And there may come a time when the owners say, we don't like that. We only want people serving on our board that are owners of property, that are members of the association. So you might need to amend your Articles of Incorporation to state just that all board members must also be members of the association. So that's typically a 2/3 vote of all the members, unless the declaration provides for a lower number. So you've got to review the documents. The articles may also have amendment language in there. If they don't, you look to the declaration. If the declaration does not have language about amending your articles, then what you want to do is look to state law, and it has a procedure on how to amend Articles of Incorporation. Let's talk about amending the declaration, also called the restrictions or the CC&Rs. There's a lot of different names which can be confusing sometimes. of what that document is. But typically when you say the declaration, you're talking about the deed restrictions, what some people call the CC&Rs, the restrictive covenants. And there's typically amendment language in the declaration. There's a state statute now that says for single family, so these are non-condominium developments, that 67% of the owners can amend the declaration, or if the declaration says it's 51%, then it's the lower percentage, it's the 51%. So if you look at your amendment language in your declaration and it says that it takes 75% of the owners to amend, by statute, that's lowered to 67%. If you take a look at your amendment language in your declaration and it says 51% to amend, then it's 51% to amend. The effect of the statute is to lower it to 67% if your declaration has a higher percentage. For condominiums, typically it's 67% of all owners, or if the declaration contains a higher percentage, it's the higher percentage. That might not seem to make sense, but that's the state of the law right now. So, always when you're going to amend, the first thing you want to look at is your declaration to see what the amendment language says in there and make sure that you follow it, knowing that if you're in a non-condo, your percentage can be lowered if it's above 67%. The bylaws. A lot of bylaws have amendment language in there, or most of them do, and it'll say either the board can amend the bylaws, or it may say that the owners may amend the bylaws. There's also a Texas Business Organizations Code provision that says that the board has the power to amend the bylaws. In some cases, we believe this may kind of supersede the amendment language that's in the bylaws. And we'll talk about that. I'll show you that statute in just a second. But so keep that in mind, is that if you look at your bylaws and they say that they may be amended by the owners, there may be a way to have the board amend those without an owner vote. And it's really dependent on what the language in the bylaws say. Some bylaws may say these shall only be amended by the owners. The board does not have the authority to amend the bylaws. In that case, then obviously it's going to take an owner vote. So I guess the point is to keep in mind that even if your bylaws say it's an owner vote, talk with your attorney about it. There may be a way for the board to amend those bylaws without an owner vote. And, a lot of owners get upset about that. They'll say, why are you doing this? We should be able to vote on these. And my response to that is typically, look, pretty much everything in the bylaws is already regulated by state statute. There's some holes to fill in. For example, state statute doesn't say how do you break a tie when you have a director election. So that can be something that can be added in the bylaws, but all the important things are already controlled by statute. And, I believe that the board should have the power to amend those to bring them into conformance with the law when the law changes. And as long as, the board's not trying to abuse and trying to sneak restrictions into the bylaws, I don't have a problem with the board amending the bylaws as long as it's allowed by statute and the language in the bylaws doesn't prohibit it. Architectural builder guidelines, we talked about those. Those are typically adopted by the board or the Architectural Control Committee, and they can be amended by the board or the Architectural Control Committee, depending on what the language in your declaration says. Rules and regulations, again, that's typically something that the board is going to have the power to amend. Whenever you've got a board that wants to say, we want a rule that says this, what you need to find is where does the board have the authority to adopt that rule? So again, it takes looking at the declaration. A lot of declarations expressly state that boards have rule-making authority. So you need to look for that. And if it's not in there, you need to look in the law to see if there's some authority for the board to adopt certain types of rules and regulations. Again, as a manager or as a board member, when you want to adopt a rule or regulation and you don't see something specific in your governing documents, that's something you should talk to your attorney about to see if you even have the authority to adopt that rule or regulation. And hopefully your attorney can advise you on that. So just want to point out a few statutes here. And I believe that this presentation will be available if anybody needs to look back at these for reference. Texas Property Code, Chapter 209-0041 contains some language about amending the declaration. You should keep in mind that if you're taking an election or an association vote outside of a meeting, the statute says that you have to give the owners at least 20 days notice of the election or vote and give them that amount of time to cast a ballot. Property Code 81.111 speaks to amending condominium declarations for pre-January 1, 1994 condos. And what that means is if your condominium was established prior to January 1st, 1994, it's governed by Texas Property Code Chapter 81. It's generally referred to as a pre-TUCA condominium. TUCA is the Texas Uniform Condominium Act that became effective on January 1, 1994. So Property Code Chapter 82 is the Texas Uniform Condominium Act, and Section 82.067 speaks to amending declarations for post January 1st, 1994 condos, which are TUCA condos. And then also be aware of Section 82.070, which speaks, again, this is for post January 1, 1994 condos, how you can adopt amendments to your declaration or your rules or your regulations, which has to occur at a meeting, and there's some provisions in there that have to be followed. Just to make everything a little more confusing, there are some sections of Chapter 82 of the Property Code that apply to pre-TUCA condos. So you should be aware that there are some sections that apply. 82.067 and 82.070 do not apply to pre-TUCA condos. But at the beginning of Chapter 82, there's a list of the sections that apply to those pre-TUCA condos. I mentioned earlier of the section of the Texas Business Organizations Code. This is it. It's Section 22-102. And it says the board of directors may amend or repeal the bylaws or adopt new bylaws unless this chapter or the corporation's certificate of formation, also known as the articles of incorporation, wholly or partly reserve the power exclusively to the owners. The management of the corporation is vested in the corporation's members. So typically the management of association is vested in the board, not in the association's members. It's not in the owners. The management power is vested in the board. Or if there's been an amendment where the members expressly provided in the bylaws that the board may not amend or repeal the bylaws. Again, this can be a little bit tricky. There's a little bit of nuance, especially to Section 1 there. So if you look in your bylaws and they say that the bylaws may be amended by the members, that's something you may want to talk to your attorney about. And, you know, to be honest, there's kind of there's not a consensus in the industry of how to use this chapter. So it's something you need to talk to your attorney about and let them advise you of the pros and cons of using this chapter to amend your bylaws. And again, amendments, you know, are things like quorum numbers, terms of directors, as long as they do not conflict with state law. Something to keep in mind is Property Code Section 202.006 states that a property owners association shall file all dedicatory instruments in the real property records, and that if it's not filed, it is not enforceable. And this applies to condos and non-condominium developments. So, you know, every manager should know this. Every manager should make sure that all of the association's documents, governing documents, are filed with the county in which the association is located. And also, I just want to make a note. If you've got a question, you can type it in the chat. When we're done here, I'm going to try to get to as many questions as we can. So this is in Property Code Section 207.006, and it's a relatively new law that says that if your association is composed of at least 60 lots, or if it's smaller than that and you have retained a management company, you must make all of your dedicatory instruments available to the members on a website. So it's important to note that this does not apply to condominiums right now. We suspect this may change where either this or something similar to this is going to apply to condos. So keep that in mind if you, especially a small association out there, that if you have retained a management company, you've got to put all of your dedicatory instruments on a website. And obviously, if you're larger than 60 lots, everything needs to be on a website. And you don't have to put in any on the website, any governing documents that have been superseded or replaced. It should be your current documents. And you should just make sure they're all there. There's some associations that have numerous policies and guidelines, and we find a lot of times that not everything makes it to the website. And this should be kind of a thing for you managers that, maybe once a year you take a look, make sure that you've got everything on the website that is supposed to be there. And again, the governing documents, outline what the association is supposed to do, what the functions are. And, some of these are kind of no-brainers. It's prepare and adopt budgets, set and collect assessments, enforce restrictions, upkeep the common areas, execute contracts when necessary, hire staff if you're in a position to where you need staff to do things, set rules for the community and maintain membership records. Typically all of this are things that are set out either in your articles, in your bylaws, in your declaration, or kind of a combination of all three of those documents, that you have the authority to do these things. And then state law gives corporations, nonprofit corporations, the authority to operate the association, which includes all of these things. And again, restrictive covenants, and this is, we're speaking of the declaration, can state state actions that are permitted on a piece of property. They might state what's prohibited on a piece of property. And again, this is looking at your declaration, the rules of what you can and can't do with your property. But those rules may include things you can do and things you can't do. And also, they will typically state your declaration who has the right of enforcement. I think the next slide might talk about that a little more. Oh, somewhere it is. But typically, every owner has the right to enforce the deed restrictions. Now, obviously, that doesn't include, they can't collect the assessments, but all the rules of what you can or can't do with your property can be enforced by both the association and every owner. Restrictive covenants, I'm sure you have all familiar with what restrictive covenants are. If you have one restriction, it is typically that you have to use the property for residential use, that non-residential uses are prohibited. That was the first deed restriction. A lot of them prohibit multifamily occupancy, require that you maintain the improvements on your property in attractive, and this gives the board the authority to try to get people to paint their house when necessary. And most restrictions require that before any type of improvement is put on the property, it requires architectural review. And this one can be a little tricky, especially if you're in an older subdivision, an older association, where I've seen a number of times where the restrictions are written that say that no building shall be constructed that without getting architectural review. Well, modern restrictions say you can't do anything. You can't put a fountain in your yard. You can't do anything. So if you're in an older subdivision, you need to really read your architectural review provision carefully and see exactly what has to be approved and what does not. This is what I mentioned early. Owners have the right to enforce use restrictions on the property. So, before there were associations, the deed restrictions were typically contained in the deed. Your actual deed to your property would have restrictions in there. And so when the developer first sold that first piece of property, the restrictions would be in there. So everybody would have, in a subdivision, would have a deed that said that there were these restrictions. And at that time, the only people who could enforce them were other owners in the subdivision. So you can enforce against other owners. And then when associations came along, owners kind of stopped enforcing in most cases, and they looked to the association to enforce. Now, the problem with that is sometimes what the owner thinks is a violation, the board or the association may not necessarily agree that that's something that first off, that it's a violation, or if it is, it doesn't rise to the extent where they need to use association resources to enforce it. We have a lot of issues with neighbor to neighbor disputes, and probably the most famous or the infamous, and I'm sure that every manager has dealt with, is the barking dog dispute. And what I typically tell boards is that if you have one neighbor complaining about a barking dog and you have a restriction that talks about noise violations or barking dogs, that's really not an association issue. That's two neighbors having a dispute and they need to work that out themselves. Now, if you have a barking dog and that house is surrounded by a property on either side and maybe two properties in the back, and all four neighbors are complaining about it, that might be something the association needs to step in and send a violation letter on, because it's really affecting more than just one person. What you want to do as a board is just try to stay out of neighbor to neighbor disputes. You typically can't make either neighbor happy, and a lot of times it's not so much the barking dog or the tree limb that comes over their property. It's more that they just don't like each other, and you want to try to be able to recognize those situations and stay out of them if you can. Like I mentioned before, owners can't collect assessments, but keep in mind that owners can enforce the restrictions. And a lot of times I tell owners that, or I tell the manager that, look, you need to tell this owner they have the exact same right as the association to enforce a use restriction. The association's right isn't greater, it's the exact same. And if the association has declined to take any action, then they need to talk to their personal attorney and they need to take action to enforce what they believe to be a violation of the restriction. And now I'm just going to mention very briefly, talk about collections and deed restriction enforcement a little bit. Collections obviously is a very important to every association. Most associations, the only income they have is what they collect in assessments. And there's always that threat of foreclosure that an association has, assuming, of course, that the declaration secures the assessments and other charges by a lien on the property, and that lien can be foreclosed on by the association. It is important to note that there may be some charges that are not secured by the lien. So there may be some charges that are due and owing, but if they're unpaid, the association doesn't have the leverage of foreclosure to collect them. And typically this is in older associations for things like deed restriction attorney fees. Most older sets of declarations do not secure deed restriction attorney fees by a lien on the property. So you can still file a lawsuit if you have to. You'll get a judgment for those deed restriction attorney fees. Hopefully they're not cut too much by the judge. And then you will have a personal lien against the owner to pay those, but you can't foreclose on their property to collect things like deed restriction attorney fees if the property is the owner's homestead. So really, again, this is another thing where you should be familiar with your governing documents and you should know what charges are secured by the lien. And again, that means those charges can be foreclosed on, and they are typically the assessment, interest, collection costs. They may be late fees. The charges that are typically not secured by older declarations are deed restriction attorney fees, late fees, fines, things like that. And again, most associations have the foreclosure option. Typically, it's for non-condominiums, it's judicial foreclosure. And what judicial foreclosure means is that you file a lawsuit, a judge signs a judgment, and a constable or sheriff then sells the property. Non-judicial foreclosure is the type of foreclosure that's used by condominiums a lot, and they can foreclose kind of like a lender. You just have to give 21 days notice that on the first Tuesday of the next month that the association is going to foreclose on your property for non-payment of assessments. There was a time when some non-condominium associations could exercise non-judicial foreclosure. By law, they cannot anymore. If you have non-judicial foreclosure authority for a non-condominium assessment, you have to go through what's called an expedited foreclosure process, where you have to file a petition with a court and in effect get permission from the court to non-judicially foreclose. This non-expedited foreclosure was supposed to maybe speed things up and help things, but what we found is it became very cumbersome. There were several effective ways to stop an expedited foreclosure in its tracks. We generally don't recommend using it, except in some cases. And with judicial foreclosure, you've got a judge that sees everything, a judge that signs the order, and a third party, the constable or sheriff, that actually sells the property. So kind of the takeaway from today is, and I mentioned it a few times, is, if you're a manager, you should definitely have read and understand the governing documents. And obviously you can't keep all of the governing documents for every association you may manage in your head, but generally you should know at least what's in the declaration, what's in the bylaws, and if there's anything in the articles that you need to know about. So those three documents, you should have some, be familiar with those to some extent. And always ask your board members to do the same. A lot of times board members, of course, it's a voluntary job. They're not getting paid. They've got other things to do. They've got jobs, and they may not have time to read it. But, I try to advise them to do the same, to have just kind of a general knowledge of what the governing documents say. If there's foreclosure authority, what are kind of the big restrictions, that violations of which the board needs to be on the lookout for, and to know how the association operates, how the bylaws say it operates, to be familiar with the election process and who can run and who can't run, and kind of some of the basics of that. I think that might be the last one. If it is, I think we can maybe try to answer some questions. Let's get up to the top here. This isn't working well.
You need me to read the questions, Cliff?
All right, I got it.
All right.
Can articles be changed under developer control without a 2/3 vote? I would typically say they can't, but again, I think it's going to depend on what those articles say. So that definitely sounds like something you would want an attorney to look at if you think that the developer is wanting to or has changed the articles and it hasn't been done properly. Would you recommend a board to amend bylaws by community vote, even if the documents say may amend by board vote? Yeah, again, I think that amending, well, I think that amending bylaws typically should be a board function, and hopefully, the board is acting correctly and amending them to bring them into compliance with the law and to fill in any holes that aren't there. But yes, if that authority is in the bylaws for the board to vote, the issue with taking a vote to the owners is that the board or its attorney prepares a set of bylaws that brings them into compliance with new law, and then they put them out for an owner vote and the owners reject them. And, puts you in a position of, well, we still have to follow all these laws. And, now we're operating under the set of bylaws that conflicts with the law, and it just creates a confusing situation. I have a large community that is in 3 different counties. Do the documents need to be filed in all 3? Says communities, but I think probably meant, do the documents need to be filed in all 3 counties? Yes. Every county in which any property under the jurisdiction of the association touches, the governing documents need to be filed in all of those counties. See, is there any guidance for a POA on how to prepare the new CCRs for a vote? Meaning, is there a requirement for the POA to show what changes were made in each article section? Do members have to vote yes or no on the entire document, or can they vote on sections of the new document? I think the best advice is, if you're going to amend the declaration, you need to show the owners what you're amending. So show them what was there, show them what it's going to be changed to. I'm going to kind of give a bylaw example. I have a lot of associations where they say, we want to redo our bylaws, and I look at their bylaws and they're from 1993, and I don't even try to fix those. There's just no way to fix them. So on that, it can be difficult to explain to the owners what's happening, because it's just going to be an entirely new document. The declaration amendments might be a little different, to where you should try to show what was there, what's being changed. They don't have to vote yes or no on the entire document. You can do an amendment by amendment vote. That can be a little tricky. But you should talk to your attorney on how to format that. So it's really a choice of the board on, do you want to do it all or nothing, or do you want to have a number of amendments and then have the owners vote on each one? Can a community waive a portion of the assessments? We recommend against waiving assessments. Typically the documents say that the assessments have to be uniform, and we believe that, generally speaking, you should not ever waive assessments. Now, might be some exceptions to that if you're trying to resolve a lawsuit and there's an issue with, notice, or there's some issue where the association may be at fault. That'll be a settlement of a lawsuit, and again, something you need to discuss with your attorney on any kind of waiver that you might want to think about to try to resolve that lawsuit. When discussing liens, you mentioned the phrase, if the property is the homeowner's homestead. Can you foreclose a non-assessment lien if the property is not a homestead, such as a rental property? So I think what they may be asking, and I'll just give an example. So if your declaration doesn't secure deed restriction attorney fees by a lien on the property, and you file a lawsuit to get a deed restriction cured, and the judgment in that lawsuit incurs an award of attorney fees, if you can find what's called a non-exempt asset, piece of real property that's a non-exempt asset, you can foreclose on it. Now, what that means is a piece of real property that is not the owner's homestead. So again, I guess the message, and hopefully I'm making this clear, is if you have amounts that are not secured by the lien, you cannot foreclose on an owner's homestead to collect them. If it is a rental property and is not their homestead, and you have a judgment for those amounts, you can foreclose on that property. And you'll just have to get with the constable on what they need to show them that that's not an exempt piece of property. It's not their homestead. You've got a judgment and against the owner of that property. Is a board member considered an employee during and can be discussed in executive session? I don't think a board member is an employee, and I'm not sure what the rest of that means, but I don't think a board member is an employee. If we only send a notice for the amendment of the CCRs along with the proxies, can we extend the voting after the meeting to meet the requirements? Well, so there's a couple things I might have an issue with that question. One is, unless the declaration expressly provides that you can use proxy voting to amend the declaration, I generally advise associations that you cannot and should not use proxies. So, and I guess that's another point I want to make. But if you're going to amend your declaration, you need to carefully review the amendment language on what it takes, and you have to follow that language exactly. And there's a lot of case law out there, and I'll give you an example. There's language that says that the declaration may be amended by 51% of the owners of the properties. So if you've got 100 properties and you've got 2 owners for each one, you've got 200 owners, that type of language could mean that you need 101 owners to amend the declaration. Now, if it says it's 51% of a majority of the lots, then you look at the number of lots you have. So the point is, you need to read that language carefully, determine exactly what it means and who needs to approve. And again, if it doesn't expressly state proxy that you can use proxies for declaration amendments, my advice is don't use them. You have to get owner signatures on those. With regard to giving deadlines, what I typically tell associations is that I don't think the law is crystal clear that amending a declaration is a vote outside of a meeting. I mean, arguably, clearly it is. And that kicks into effect that kind of 20-day notice. So what I tell associations when they're amending declarations is start getting your signatures. And once you get what you need for it to pass, then send a 20-day letter and say the deadline is 20 days from now. And then I think it kind of covers you to where you've complied with that provision of the property code, if it does indeed apply, nobody can argue that you violated it. Hopefully that helps with that question. This one's kind of a long one. Any homeowner who receives a request to approve additions or amendments to the bylaws I don't think that I can answer that question really without, it's a kind of a complicated question with what looks like some overly complicated language about getting owner approval of bylaw amendments. I don't think you can tell owners that here's what we're going to amend. If you don't respond within 30 days, you're deemed to have approved it. I don't know that I like that. I don't know that a judge would like that if you're trying to use that as a basis to say this owner approved the bylaws. Again, I would talk with your attorney about that and see what their opinion is. If an owner made a improvement in their backyard but failed to obtain ACC approval, how much time must pass from the date of the improvement until the homeowner's violation is considered waived or unenforceable? So that's really, I think what you're asking about is what is the statute of limitations? For deed restriction violations, it's 4 years. So if you see somebody that puts an unapproved shed in their backyard or in their front yard or wherever, you've got 4 years to file a lawsuit to make it go away. If you don't, and you file a lawsuit after 4 years has passed, the owner can assert the defense of statute of limitations. And as long as they can prove that that shed has been there for 4 years, they will win that lawsuit. You will not be able to win that lawsuit. So, hopefully for any kind of violation, you're not waiting that long. However, it kind of happens more often than you think, where all of a sudden you're starting to bump up against that statute of limitations, and it can be an issue. Let's see, we got some long questions today. So these people are trying to amend their declaration to add lease restrictions, and they've been at it for 48 months. It says the bylaws state that the board can amend the policies of bylaws. Do the CC&Rs, the declaration, fall under that piece of the bylaws? No. I mentioned earlier that when you're amending the declaration, you have to look at the amendment language in the declaration. And if it requires an owner vote, that's what it takes. And typically, there's not a time limit that you have to get the owner vote. I have had a couple of amendments that have taken 2 to 4 years for them to get enough signatures to pass. If it is taking you a long time like that, one thing you need to remember is that when you go to file that declaration, you need to confirm that all of those owners that signed are still the property owners. Because what you don't want to find out after the fact is that, you barely made it. You barely got to that 51%. You file the declaration amendment, and then somebody challenges saying that, 3% of those people had sold their property by the time you filed it. And so their votes don't count anymore. And they would be right. So, sometimes you got to keep at it. But if you do take a long time, when you go to file that declaration amendment, make sure that the people that signed it are still the owners of the property. Is the term resident same or different from the definition of member? So, resident probably refers to who lives in the property. That might be a tenant, so it doesn't necessarily make them a member. So members are usually defined as the record owner or owners of the property. And what that means, record owner, means their name is on the deed to the property. How far back can you go on an unpaid assessment when moving forward with the foreclosure? It's the same statute of limitations. It's 4 years. So on January 1st of 2024, the 2020 assessment, the collection of the 2020 assessment will be barred by the statute of limitations. Now, let me clarify that, is that what that means is a debt collector can't collect or make a demand for that assessment. So after January 1st of 2024, if an association turns an account over to our office and we see that there's the 2019 and the 2020 assessment is due on that account, we can't even ask for it. That's a violation of the law. Now, that doesn't mean the association has to take it off of its books. It can leave it on there, and at some point, the owner may pay. But what that means is a debt collector can't try to collect that debt that's more than 4 years old. Can an HOA board adopt its own fine schedule, or does this need to be voted on by the homeowners at a board meeting? So the first question is, if you're thinking about fining, is do you have the authority to fine? And again, that will take a review of your governing documents to look in there to look for fine language, or maybe the authority to levy a penalty if somebody violates the restrictions. This is not something, this is again something where there's not a consensus in the industry um, of can you just adopt a fine policy and levy fines if you don't have that authority. We generally discourage associations, or we let them know that, hey, we don't see fining authority. So we think if this policy got challenged, it might not survive a legal challenge. So let's just assume you have fining authority. We think that's a board function to adopt a fine policy, unless your documents say that in order to adopt a fine policy, it has to be approved by the owners. So again, it's with pretty much every question, it's what do your governing documents say? That's the first place to look. So in this case, your governing documents say you can fine, doesn't require a vote of the owners. We think the board can adopt that. One thing about fines, just a quick note, is we have some associations that think they're going to fine people into compliance, into submission, and a lot of times levying fines just leads to an argument over the payment of fines. Don't adopt a fine policy thinking it's going to work on everybody. It may work on some, but if somebody's not curing their violation, and you've got $30,000 worth of fines on their account, I can pretty much guarantee you are never going to collect those. At some point, you got to stop fining and file a lawsuit. Let's see, our CCRs were done in 1999 when the houses were built. We'd like to change some of the wording and make them less strict. Do we need an attorney for this? So the question is, can we amend our restrictions without an attorney? Yes. Any owner can prepare an amendment, and if they go around and get enough signatures, they can amend the declaration. There may be an exception if the declaration says only the board can, draft and put out amendments. I don't know that I've ever seen a declaration that says that. Now, having said that an owner can draft an amendment and get signatures and amend, I would suggest that you at least talk to an attorney about it. You don't want to spend the time and effort it takes to amend the restrictions, only to find out that what you've written is vague or unenforceable for some reason. It's any deed restriction amendment. If you want to pass a deed restriction amendment that says that you can't park your car in the grass in the front yard, it's going to be difficult to pass. It's going to take work. And, I usually tell every board that starts talking about it is, first, don't spend any money on me unless you think there's a chance that it's going to pass. If you haven't talked to the owners about this and got some support, you're probably wasting your money. And if you do think it can pass, it will likely ultimately take knocking on doors to get those final signatures to push you across. So, if you're not willing to do that legwork, it's another consideration when trying to amend your declaration. There's a question about an Illinois HOA. I really don't know of another resource other than, maybe trying to Google Illinois Homeowner Association attorney. I am sure that they are there. I have a set of declarations that states each new day a violation is new. And this section of the CCR is intentionally stated so that there is no statute of limitations. I don't think that's valid against the statute of limitations. So if you've got somebody that has a car in their front yard with no wheels, I don't think, no matter what your declaration says, if you don't do something within 4 years, you're not going to be able to do anything. Oh, so I guess maybe I didn't answer one of these questions earlier about a extension of trying to gather signatures for a deed restriction amendment. Yeah, I think the board can make a decision, even if they set a deadline, to say, you know what, we're going to extend this. So if you get to that point where you don't have your signatures and you decide we're going to go for 4 more months or whatever, you should do it. Again, I think the better practice is to not ever give a deadline, but until you've got your approvals, and then give a deadline to vote. Can a POA go door to door to get signatures? Yes, that's what it takes sometimes. You just got to be careful that the person that's signing, the person you're talking to, is the record owner of the property, meaning that their name is on the deed to the property. Ooh, there's a really long one about a bylaw amendment and declaration amendment that I don't think I can answer in this setting, because I'm going to have to sit and think about it. Can an association give a blanket variance? In other words, anyone in violation yesterday is given a variance, but starting today, it is a violation that will be enforced. Anytime you try to do something like that, it's going to be troublesome in that time period after you start enforcing. So usually when I see something like this, it's owners have been doing something that is not necessarily against the governing documents, but the association doesn't like it. The board doesn't like it. Some of the owners don't like it. So they put into effect a guideline and say, we've adopted this guideline. You can no longer paint the brick on your house. And then for a while, after they try to enforce that, and let's just assume it's enforceable, somebody's going to go to paint the brick on their house, and they're going to say, all these people did it. And you're like, yeah, but nobody's done it since we passed this guideline. Everybody that's applied to do it since we passed this guideline, we've denied, and we're going to deny you. And the owner may go away. They may still insist on doing it, at which time you've got to make the decision, are we going to try to enforce this legally? And it just really depends on the circumstances and how many other houses there are, and if you can actually show that you've denied people that to do that same thing since you've passed that guideline, or since you've amended the declaration, or whatever it is. You may have a chance of winning that. So it will be difficult. With regard to blanket variances, I've had a few. I've had some where their declaration says that your roof has to be weathered wood, and then they start getting people that have kind of different shades or different colors of roofs, and assuming that their declaration gives them variance authority. So that's another kind of thing to point out, is we think you have to have variance authority to give a variance. And they've said, you know what, we're just going to adopt the variance and say that these roof colors are also acceptable. And they haven't had a problem with that. Typically you're not going to get an owner that says, I don't like that. I want everybody to stay with weathered wood. And especially if there's already a handful of scattering of other roofs in the neighborhood that didn't comply with that restriction, and now it's too late to go back and try to get them. If an owner has been in bankruptcy for 10 years and the association is unable to collect assessments, will the association only be able to collect any of those first 6 years? That's a good question. It reminds me that there is an exception to the statute of limitations. So bankruptcy tolls the statute of limitations. So let's say that you have an owner that owes you the 2020 assessment. They file bankruptcy on January 1st of 2022. So 2 years have run on the statute of limitations. 2 of the 4 years have run. They come out of bankruptcy 6 years later, January 1st of 2028. The clock starts ticking again. So you've got 2 years after that. So while they're in bankruptcy, the clock stops ticking on the 4 years. Once the bankruptcy is dismissed, the clock starts ticking again. Now, that doesn't take into account how the bankruptcy is disposed of. If it's dismissed, that means that the owner did not do what they were supposed to do, and there's no protection. If it's discharged, which means they successfully completed a bankruptcy, the owner may no longer be personally liable for that assessment, but the property may be responsible for that assessment. And that's kind of a difficult concept sometimes to understand. And the takeaway is, if you have a bankruptcy that was discharge, you need to talk with your attorney about if and how you can collect that assessment. And that tolling counts toward pre-bankruptcy assessments and post-bankruptcy assessments. So somebody files bankruptcy on January 1st, 2020, let's say December 31st, 2020, and they're in bankruptcy for 5 years. Every assessment that came due during that time, the clock starts ticking at the end of that bankruptcy. So again, bankruptcy can be tricky. You've got to be very careful. If you a management company and you send a letter for a pre-bankruptcy debt after a bankruptcy has been discharged, you may have violated the bankruptcy stay. It's a strict liability statute, meaning it doesn't matter if it was an accident or if you knew or didn't know. So you've got to be very careful with how you handle bankruptcy discharges, and that's something you should definitely talk to your attorney about. Can discussing possible interim board members be done in executive session and voting be done once coming back to the open session? So the property code lists some things. It states that the board can adjourn into executive session to discuss, and it has a list of, I don't know, 5 to 7 things. None of those is discussing board members to fill vacancies. So arguably, my advice to every association, every board is, look, the intent of the law is that all association business be conducted in the open session of a properly noticed board meeting. Now, there's some exceptions, and the property code allows for it, where in executive session, you can discuss violations, who owes money. You can negotiate contracts with vendors. If an owner wants to have a talk and they want it to be in private, you can do that in executive session. So there's some things you can do there, and they should be done there. But really, the law wants the members to see you talking about other things. So just try to keep that in mind. And obviously the law allows you to make some decisions by email between meetings. If the pool pump breaks, you can't wait till the next board meeting to get that fixed if it's the middle of the summer. You can make that decision by email. Every board member, every manager should be aware that there are 15 things that you cannot do by email between board meetings that have to be done in the open session of a properly noticed meeting. Those include things like initiating a foreclosure action, initiating a deed restriction, amending a declaration or amending a governing document, appointing someone to fill a vacancy on the board, officer elections, and there's a handful of other things that everyone should be aware of. If you're a board member listening, you should ask your manager to give you those things. And if you're a manager, you should provide that list to all of your board members. And hopefully that's something that they will know. I mean, if a board member only knows one thing about the property code, that's probably one thing they need to know. Can you require homeowners to pay HOA dues through the escrow accounts when purchasing a home? I think that probably has more to do with the lenders. I don't, from what I understand, lenders don't do escrow accounts for paying homeowner association fees anymore. This comment says it is setback lines for the variance. Again, anything having to do with the variance, you need to make sure that you've got the authority to give the variance, and sometimes variance authority is limited. So make sure you look through your governing documents to see, first off, if you have variance authority, and in this case, if it prohibits you from giving variances to setback lines. Let's see, what can the board do when I think we've got time for 2 more. And of course, I've lost my place. What can the board do when the homeowners install the wrong kind of fence and fail to submit an AC prior to installation? When it was submitted, the ACC denied it. So the next step in that is to file a lawsuit and ask a judge to order them to cure the violation. Now, it's easy for me to say, hard to do. Judges don't particularly like telling people to tear things down, but they have and they will. It really just depends, on the judge you have, the judge you get, and kind of the facts of the case. So, anything having to do with construction, when you see something that's unapproved construction, that's something you've got to get on immediately. You don't want them to get to the point where they finished it, because it will be that much more difficult to get it undone if it's built. Now, a fence, not so hard to tear down. An addition on a house, it's going to be a little harder to tear down, and much harder to get a judge to tell somebody to tear it down. So really, when you see unapproved construction, you've got to get on it immediately. You need to go out there and take a picture when you notice it, so that if you do end up in a lawsuit, you can show the judge, look, judge, when we found out about this, there was holes in the ground for the fence post. Nothing was up yet. We told them to stop. We sent them a letter. We hand delivered it to them. We mailed it. Our attorney called them, whatever. A board member stopped and talked to them. They chose to go on building anyway. That's the position you want to be in, is that you caught them early. You've got a picture to prove what was done, and you notified them. They don't dispute that you notified them. And the judge is going to be more inclined to look at them and say, okay, you ignored all this. So you don't really have what we refer to as clean hands. You're saying it's not fair to make me tear this down, but it wasn't fair for you to keep going when they told you to stop well before you really got started on this. If it's a home construction, and you tell them to stop and they ignore it, you really have to consider filing a temporary restraining order. And that's something you want to talk to your attorney about. It's very expensive. What that means is somebody has to go down there that day and try to get a judge to order them to stop. And that might be an all-day thing. You can be thousands and thousands of dollars into TRO. That's why if you're going to do it, it should really only be for something that's serious that you need to stop. I think that's all we have time for. And Kyle, I forget, you have to remind me, do we email this to everybody, or is it just available on our website?
I'll email it to everybody, Cliff, and then the video will be posted online.
Okay, well, thank everybody for coming. And we will have another one of these soon, I'm sure. Thank you.